Hi everyone, thanks for joining me again on the Child Protection Party Facebook and YouTube channels. I'm getting a bit tired of having to completely this last week reporting to you about situations in relation to the department and their inappropriate behaviour and the way that they have neglected our community and particularly our children. It is the DCP role, this Child Protection Party's role to be able to inform you of occasions where children are being harmed by the department and by others. And here we are again with another story from the ABC in relation to parents who are suing the department for their inappropriate behaviour in having children removed from them because of a medical condition that was basically undiagnosed, and where a psychiatrist who represents the department issued a report stating that the parent was suffering from Munchausen's by proxy. Now, the issue around Munchausen's is that it's been an issue which a number of parents have had, and I would suggest any parent who has an issue where they have been accused of seeking medical advice over and over again for their children and therefore have been diagnosed with Munchausen's, I would suggest that every one of you find a way to be able to sue the department for such a diagnosis. It's a very difficult diagnosis to make. It is really about a parent's obsession with having to find a problem with their child and medically. And there are certain cases, I guess, where parents have got some psychological issues and they seek some sense of gratification from taking their child incessantly to get medical treatment. And it has often been because those medical issues have arisen because the parent themselves have induced a condition whereby the child becomes ill. And there's clearly no way we're going to support that notion. But those cases are so small, so minuscule, that they don't play a significant role, I guess. They're not evident enough to be able to become a significant issue in terms of child protection. However, I do appreciate that they do happen, and sometimes those people hopefully will get caught out. But there are occasions where the diagnosis is made without much foundation whatsoever. And this is one of those cases. In fact, I've got a strange feeling I've actually spoken to these parents before. And if you're actually watching this video or you know of those people, I'd really love to have a chat to them to find out what's happening in relation to this case, so that we can be better informed as to where it stands. Munchausen's itself, as I said, is hard to diagnose. We've got to be very careful about the diagnosis of it. And in this case, Dr. Giordani, who I must say I have a lot of issues with myself in terms of the way he presents and the way he sort of stipulates whether or not children should be taken from their parents or not. I don't want to get too much into John Giordani's situation because I don't want to be taken to court either. So I will leave that as it is, I guess. But I do want to highlight this particular article, and I want to encourage parents who have got issues with the department, and if you can afford to do so, perhaps you could think about finding ways to take legal action against them for what you'd believe to be an unjust and inappropriate removal of your child or children. So this is the article that we're discussing today. It's in the on the ABC, and it says South Australian parents sue the state over daughter's removal as the case of Charlie remains in the spotlight. So here we have, this is interestingly enough, I guess this has to be the most horrible week for the department that they've ever experienced. Not only the death of a child, but here we've got a case in which they're being sued by parents for the inappropriate removal of a child. So in this article, it goes on to say, as the South Australian child protection system comes under fire over the death of 6-year-old Charlie, and we've been reporting to you for the whole week around that and the position that the government now find themselves in as a result of their inability to be able to safely protect this particular child. The parents of 2 girls taken into care for a gluten allergy are suing the state government, claiming they were illegally removed. Now, I would have an issue with the term illegally, but I guess that's for the judiciary to sort out. But the department thought that they had a reason to remove these children, primarily because of what the psychiatrist John Gerardini had to say in terms of one of the report that he wrote in relation to these parents. Now, I know often, I'm not going to say it's John necessarily, but I know often sometimes these reports are written with very little information whatsoever. I've even known reports to be written by psychiatrists who have had almost no contact with the parents. They've just read the department's reports and have drawn conclusions as a result of those reports. Not suggesting that's the case here, but I know that that does happen. In their statement of claim filed in the South Australian District Court, the parents, who cannot be named to protect the identity of their children, alleged the state government trespassed and falsely imprisoned their children over 5 months in 2017. I'm assuming those children have now been returned to them. If the parents could contact me, I'm going to have a conversation with them about that, and I can report back further to you as to what that case, where that case stands at the moment. The lawyer Andrew Carpenter said it highlighted the disparity between responses within the Department of Child Protection, and I'd really be interested to speak to Andrew Carpenter about where he stands on this position as well, and his representation of this family. There may be somebody, Andrew might be, I don't know, but he might be someone that some of you could refer to in relation to your own cases. So it talks a little bit about what, so that this child obviously had celiac disease, I would suggest. It could happen to any parent, but DCP are required to act in the best interest of children. It's not in the best interest of the child to be taken away when their parents confirm a medical diagnosis. And the interesting thing here is, I think that with Charlie also had a medical condition. Charlie also was probably the diagnosis of that condition, regardless of whether the parents attended to it or not, but the diagnosis of that condition may have caused Charlie's death. We don't know that yet until the coroner's report comes out, but we can assume that the government may have known about Charlie's condition but failed to take any action to help protect her, and we don't know what the parent was doing at this time, the mother, and we don't know the interaction of the mother with the child and others that might have had interactions as well with Charlie. But it is interesting to note, I think, that it is important to understand that sometimes the medical conditions can be diagnosed, not understood, that sometimes, in my experience, parents have spent a lot of time attending medically around their children, and that gets misdiagnosed as the parent being overindulgent, if you like, with the child, and looking for some sort of medical explanation for what is happening to their child. Lots of appearances to doctors and into emergency centres and so forth, and then as a result of that, they get diagnosed with Munchausen's because someone somewhere on the line says they weren't able to find a specific condition that this child was suffering from. So the document stated their daughter first experienced vomiting and nausea when she was 3 years old because she consumed foods containing gluten, and was taken to see a gastroenterologist, Dr. Rupert Hines. From December 2015, in accordance with advice from Dr. Hines, the girl was commenced on a gluten-free diet, the document stated. In June 2016, she suffered some degree of non-celiac gluten intolerance, and her parents were told by Dr. Hines to continue the gluten-free diet. The claim stated the parents told the girl's kindergarten in Adelaide's eastern suburb that their daughter was allergic to gluten and needed to be on a special diet in January 2016. In February 2017, the parents attended the kindergarten and were advised by staff at the kindergarten that the daughter was not eating sufficiently, and they arranged a review with Dr. Hines. Here the problem starts. Kindergarten clearly made the report, I would assume. The parents advised the kindergarten that Dr. Hines found the now 4-year-old girl may have been experiencing a low appetite as a side effect of surgery she had when she was 13 months old, according to the documents. The government notified DCP, the kindergarten, there we go, they did notify DCP that the girl needed gluten-free diet in April 2017. Documents stated that 2 days later, without any further investigation, DCP removed the girl. So they just came in and removed her without any investigation whatsoever. And what does that tell us about DCP and their response to simply a notification in regard to this child? So I don't know what information they had. It was simply a notification that they chose not to investigate it. DCP removed the girl and her older sister from the care of their parents and placed them in care because the allergy had been fabricated by her mother. So without any investigation, the department had chosen to declare that, for whatever reason, that the mother had fabricated it. So how do you come to a conclusion like that without an investigation? It's beyond me. But this is what the department does, and this is some of the stuff that needs to be cleared up. Following the removal at the direction of the state government, the girl was placed on a gluten-containing diet, and as a consequence, she became increasingly ill, the parents claim. So they placed her on this diet, which adversely affected her. The document stated child psychiatrist Dr. John Giordani, here we go, diagnosed the girl's mother with Munchausen syndrome by proxy, a form of child abuse where a parent causes symptoms to make it appear their child is sick. Now, I know, and I don't know whether it's this case or some others that I've worked with where this diagnosis had been made without even meeting the parents. I'm not going to assume that it's this case. I suspect it might be, but this was done simply by someone reading a documentation by the department who have no credentials whatsoever in diagnosing Munchausen's to start with, but someone within the department probably did. Giordani, I'm assuming, may have read a report and made this diagnosis inappropriately. But paediatric gastroenterologist Dr. David Moore found it was reasonable for the parents to place the daughter on a gluten-free diet, which was backed up by another independent doctor in September 2017. Nick Xenophon clearly became involved in that. Good on you, Nick. And this is now our role as Child Protection Party. The parents claim DCP failed to investigate the girl's medical condition before removing her and improperly took into account a previous charge against the mother. In 2013, the mother was charged with harming her daughter by giving her lactose after surgery. The judge found it was a mistake and not born out of malice. The mother was not convicted for the offence. In a statement, a DC spokeswoman said the department's interaction with the family concluded in 2017. You messed up. As a matter of this subject of current court proceedings, the department is notified, and of course they're not. So here we have a family who has had I don't know what damage has been done to this child as a result of the removal. Trauma, clearly, given an inappropriate diet, clearly, but at the end of the day, we need to work out what is going to be the appropriate compensation for this family, and I'm assuming that this is what the court will hopefully do. So here we have another case within the same week almost of this 6-year-old Charlie dying, where the department has failed. Now, we know from Child Protection Party and all the work we do that there are heaps and heaps of parents who suffer as a result of being inappropriately dealt with by the department. And I want to encourage you as best I can to come and have a chat to us about what is happening to you, and we will do what we can to broadcast this. We'll do interviews with you, we'll have conversations with you, so you can contact us and have a chat to us just at admin@childprotection.party. We'll get you to us, and then we'll contact you, and Avery will organise a time to have a chat. We need to find ways to be able to make the department accountable. I admire people that have done what these people have done by suing the department. It's not always an easy avenue to take. It's fraught with danger and it's usually expensive. But I would assume that a solicitor will look at that case and say, well, you know, you've got a reasonable case here for us to win, and they may do it pro bono with a percentage of whatever is awarded. So I want people to focus at the moment on these issues around the department. They're under a lot of pressure. We can still add some intensity to that pressure by having these sorts of conversations, because hopefully it will push the department into making serious decisions about the way they work and about investing in what is actually in the best interest of the child, which is about not making reports that are spurious, about looking at notifications in a reasonable manner and making sure that they investigate appropriately. And more importantly, that they build relationships with parents that can ensure that those parents have a voice and therefore their children are also heard. Thanks very much for being with me, everybody. I would like you to comment below. I haven't looked at, because I'm doing this midday, so I'm not too sure whether anybody's... Well, we have quite a few people on board, which is very pleasing. So Tracy, why aren't companies like Shine Lawyers creating class actions to sue? The reason why class actions are very difficult is that not enough people put their hand up, basically. So Tracy, I don't know specifically who Shine Lawyers are, but or what state they're in for that matter. So if you could give us some further information about that, that would probably be helpful. Hi Janice, it's good to see you there. Oh, this is Asparity. So Asparity has just gone on board. I can't, in my court order it states I'm not allowed to discuss case. No, that's fine. But as the case concludes, Asparity, I suggest you might like to, or Melissa, I think it is, let us know. I appreciate the position you're in at the moment, but certainly keep us informed when that case has concluded. Right. I think all CPU workers assassinate parents' character. Tracy, not disagreeing with that. I think that happens all the time. They assassinate my own too. So there's a fair bit of documentation there. And there's someone from overseas, from the United States. That's Jessica. Thanks very much for joining us. So thanks, Melissa. Good to see you're on board as well. So if you could just let us know whether you've got a case that you think could be taken as... There's lots of people say us, lots of people tell us that they would like to sue the department. And I get that because you're angry. But the point is whether you've got a case that you can present that's likely to win. That's the issue. And clearly in this particular case, they do. And I'd like you to keep us informed as to what is happening. So if you've got any other issues, please subscribe to our YouTube page, and please like our child protection page so you can be continually informed and notified when we make these presentations. Thanks everybody. Keep in touch with us. Take care and look after yourself and your family.